that convenience does not meet the state's burden of proof. The motive in these court decisions is not voter suppression, although they've been accused of that. The motive is deference to the authority of the state legislature, which is the agency that is empowered in the Constitution to make these decisions. So that's part one. There is no such thing as a constitutional right to vote. Now, having established that, let's move forward. The second part of the talk is to suggest that the concept of rights, including the right to vote, has been understood differently in the past from what it is now. And to make this point, I ask you to go on reading your Constitution that you all have in front of you, I'm sure, and you read beyond the first 10 amendments. There are 17 more amendments. Of those 17 amendments, 7 deal with voting. 3 of the 7 are technical matters that are tangential to us tonight. The 12th Amendment provided for a separate ballot by the electors for president and vice president. The 17th Amendment provided for direct election of senators by popular vote. And the 23rd Amendment provided that 3 electors shall be appointed to cast the votes for Washington, D.C., which previously had no ability to vote in federal elections. But then there are 4 other amendments that are directly relevant, and I'd like us briefly to look at the texts of them and see what they have in common. There is the 15th Amendment that was adopted in the aftermath of the Civil War, and you'll notice it begins by referring to a right. It says, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude." This is the amendment that established the franchise for African Americans, at least for African American males, because you'll notice that in those exclusions, gender or sex is not one of them. It took another 50 years for the 19th Amendment to be adopted, which provides a parallel wording structure. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Then we go to the 24th Amendment, which was adopted in the early 60s, that says the right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. If there are any of you that have never heard of a poll tax, I'm going to get to it a little bit later in the talk when I refer to means by which a number of southern states denied African Americans the vote. And then finally, there's the 26th Amendment that was adopted in the early 1970s that says the right of citizens of the United States who are 18 years of age or older to vote shall not be denied by the United States or any state on account of age. Now, those 4 amendments have a couple things in common. They're all attempts to expand the franchise beyond what it had been at the time that they were adopted. And they all refer to the right of citizens of the United States. So, is it the case that these 4 amendments effectively recognize a right to vote that the earlier Constitution had not acknowledged? The answer is no. These 4 amendments do not establish an affirmative right to vote. They claim only that a right cannot be denied on the grounds of race, color, or previous condition of servitude, sex, failure to pay a poll tax, or age. They still leave to the states the ability to determine whether there is such a right and how it is implemented and other possible conditions under which it can be denied. Now, how can this be? The answer is that the term rights has been used somewhat differently from the way that it is used today. We tend to think of rights as a binary. You either have them or you don't. Rights are rights. But for much of our history, rights were thought about as existing on a continuum. And I'll show you an example of that continuum that recognized natural rights, human rights, civil rights, and social rights as distinct categories of rights. And natural rights are at the top of the hierarchy, social rights are at the bottom. Natural rights originate from natural law, human rights by human nature, or for religious people by decision of God, civil rights by the actions of the state, social rights by informal custom and consensus. Now, one could enjoy rights up at the top of the hierarchy without necessarily having rights at the bottom of the hierarchy, and vice versa. To show you how this worked in practice, I'm going to pick an example that's close to my heart. It's Abraham Lincoln. And this is an example of what, from today's perspective, is one of the more embarrassing things he said. In his first debate with Stephen Douglas, when they were running for the Senate, Lincoln said, and I've reproduced the quotation here, and I've not cut it short because it all matters. Lincoln said, "I have no purpose to introduce political and social equality between the white and the black races. There's a physical difference between the two, which in my judgment will probably forever forbid their living together on the footing of perfect equality. And inasmuch as it becomes a necessity that there must be a difference, I, as well as Judge Douglas, am in favor of the race to which I belong having the superior position. I have never said anything to the contrary, but I hold that notwithstanding all this, there is no reason in the world why the Negro is not entitled to all the natural rights enumerated in the Declaration of Independence, the right to life, liberty, and the pursuit of happiness." Now, when I teach this text to students, many of them, their first response is, well, this is a contradiction. How could Lincoln say that they're entitled to all the rights in the Declaration of Independence and say he has no purpose to introduce political and social equality? How can it be? Well, the answer relies on how these modifying adjectives are used. The rights in the Declaration of Independence, he claims, are natural rights. It is natural to be alive. Freedom is a natural condition. The pursuit of happiness, which was understood to mean the opportunity to better your condition through upward mobility, these were all claimed by Lincoln to be natural rights. They're part of nature. They don't depend on any affirmative action by anybody to grant them. In contrast, he refers in the first line there to political equality and social equality. Political equality comes from a civil right. So he would say in other speeches he does not support the right of African Americans to hold office or to vote. Those are civil rights. Those are political. And social equality has to do with social custom, norm, and consensus, and that's not legislated by anybody, so there's no automatic entitlement to it. Now, just for the record, Lincoln did begin to modify his view in his last months alive. The last speech he ever gave, referring to Louisiana's Reconstruction Plan, said that he would prefer that the franchise were now conferred on the very intelligent colored men and on those who serve our cause as soldiers. So he's liberalized his position about the right to, about voting, about the franchise, but you notice he still doesn't refer to it as a right that is guaranteed or provided or established in the Constitution. Now, the implication is you can have some rights, but not other rights. And therefore, to say that the right to vote in Amendments 15, 19, 24, and 26 cannot be denied on such and such grounds doesn't establish that any such affirmative right exists, but only that if the state legislature has chosen to grant that as a right to the populace, then it can't be denied on these bases. Incidentally, in a completely different context, this notion of different orders of rights is coming back into our discourse if you listen carefully to the debates about healthcare. The question is sometimes asked, is universal healthcare a right? If it is, it ought to be provided to everybody. And in answering that question, some speakers have distinguished between what they call legal rights and moral rights, suggesting that in the name of morality, everybody ought to be entitled to access to health care, but as a legal matter, it's not a legal right. Now, I was asked to talk about history, and I've been back in the 19th century, so that's historical. But the point that I want to try to make in the third part of this talk is if we examine our history, we'll find an oscillation between efforts to expand the franchise and efforts to restrict the franchise, an oscillation between inclusion into the political society and exclusion from it. And contrary to what Dr. King said, we will find that the arc of history bends in no particular direction. It bends sometimes toward inclusion and sometimes toward exclusion. Now, I'm going to talk about this from the standpoint of several examples. I'm not going to go into great detail on the examples because that would run away with our time. So at the outset, I want to suggest a few books that I have found very helpful in case anybody wants to pursue this aspect of the subject. These are three books that are not specifically about the right to vote, but that talk about the right to vote as a prime example of this back and forth movement between inclusion and exclusion. They're Roger Smith's book called Civic Ideals, Michael Schudson's The Good Citizen, which traces what citizenship means across different eras of US history, and Eric Foner's recent book on Reconstruction and the adoption of the Reconstruction Amendments to the Constitution. But let's see what I'm talking about. Here's the first example. This is in the early 1800s. This period of time was characterized, on the one hand, by democratization of the state constitutions. Almost every state in the Union rewrote its constitution in the 1820s and 30s in order to make it more democratic. And the primary way by which it did so was to remove property requirements that most states had previously established as prerequisites for voting. So that, as a practical matter, suffrage became universally available to white males, regardless of whether or not they owned significant amounts of property. And this expanded the electorate. The justification for it, which was pioneered by the newer states, was that the common people were every bit as good as the elites and every bit as capable of exercising their judgment and no more likely to be swayed by their passions. This was also a period that was marked by the organization of what's called the second party system, the Democrats and the Whigs. And in the second party system, as it happened for a whole variety of reasons, party identification was one of the most significant aspects of a person's identity. This was before sectionalism really developed and became the big thing and took over that priority from party. So voting was a social matter. It was not secret. You declare your vote publicly. Representatives of the parties would be there at the polling places to ply the compliant voters with ample amounts of liquor and other refreshments. And the result was unusually high percentages of the eligible population that voted. The voting percentage went from 29% in 1824, before many states had given the power over to the citizens, to an all-time high, get this, of 80.2% of the eligible voters who voted in the 1840 election, the election between Martin Van Buren and William Henry Harrison. Now, granted, the eligible electorate was much, much smaller than it is now, but that 80% figure has never been approached in subsequent elections. Well, those are clear signs of expanding the franchise. But there's another side to the story. In those same years, many of the northern states that in their original constitutions had permitted free blacks to vote disenfranchised free blacks at the same time that they were establishing equality among white males. And those two actions were related. One of the things that made all white males equal is that they all stood in a different relationship from blacks to the act of voting. This was justified by otherwise very intelligent people appealing to the scientific racism that characterized many of the early social sciences of that day, typified by the studies of phrenology. Phrenology was the art or science of determining character by examining the bumps on one's head, and it was thought to be a very scientific enterprise, even more so than ingesting bleach. And the idea of scientific racism was there was physical evidence that established that blacks as an inferior race were less capable of the judgment involved in coming to the vote. This was also the period of time under the nativist movement of the 1840s in which the United States began establishing immigration restrictions, not so much to keep people out of the country, but to keep people from becoming citizens once they arrived in the country as immigrants by extending considerably the period of naturalization that was required before that could happen. So here we see both an attempt to expand the franchise and an attempt to limit it coming at about the same period of time. Second example. This is the post-Civil War period. I've gotten ahead of my notes here. Excuse me a second. The story of the 15th Amendment is a complicated story. African Americans were granted citizenship in the 14th Amendment, which said that all persons born or naturalized in the United States are citizens thereof and of the state in which they reside. And there was some attempt made to say, well, that established the right to vote. But the quick and easy answer to that was no, citizenship does not entail the right to vote. The right to vote is a privilege that may be granted or withheld by the state legislature. The 1868 election results between Ulysses S. Grant and Horatio Seymour were very close. And during that election, blacks, newly freed blacks in the South, by and large, were not eligible to vote. And so the Republican Party realized that for it to stay in power, it would be very helpful to add the votes of African Americans in the South, who presumably would vote Republican, to the party's totals. And that prompted a legislative push for another amendment that became the 15th Amendment, which I quoted earlier before. This was a tremendous expansion of the franchise. It now became essentially universal among males without regard to race, color, or previous condition of servitude. Ratification of the 15th Amendment was a requirement for the still unreconstructed states of the South, so there were some ratifications that way. In the North, the votes on the amendment were very close because many Northerners, along with their Southern counterparts, believed that blacks were inferior. And this was justified not by the scientific racism of the 1840s, but by a racism that grew out of social Darwinism in the years after the Civil War. So at the same time that this happened, and largely in response to it, those states that wished to continue to exclude blacks adopted an amazing number of what I will call face-neutral but discriminatory voting requirements. For example, here let me talk about the poll tax. Many of the southern states in particular instituted a poll tax. This was a tax you had to pay in order to be eligible to vote. The tax was relatively low for most people. I remember growing up in Texas, the poll tax was $2. It's probably the equivalent of about 20 now. And you say, well, who can't afford that? But in fact, there were a lot of people, predominantly African American, who could not afford it. Plus, the poll tax typically had to be paid at the very beginning of the year with a January 31st deadline for an election that's coming up the following November. So it's not on people's minds at the moment. So those who are not politically active or political junkies are going to miss the deadline for paying the poll tax. And that will disproportionately affect African Americans. An even clearer example was the literacy test, which was administered by requiring that the applicant to vote interpret a passage from the state constitution selected by the voting official to the satisfaction of that official. And it was entirely discretionary whether what clause would be chosen and whether an interpretation would be considered satisfactory. These represent de facto, but not de jure, denials of the vote to African Americans. Another example was the decision by a number of southern states to adopt what was called the white primary. Here's the reasoning. The political parties are not public entities, they're private organizations. The political parties run the primaries. Therefore, the political parties have the power, if they wish to exercise it, to exclude voters of a particular race from the primary. Now you say, does this matter all that much if they can still vote in the general election? But at this time, most of the southern states were effectively one-party states. They had been recaptured as a result of measures like the ones I've just discussed by unreconstructed whites, and they voted solidly Democratic. And this continued really until the 1950s. So the primary was the key election. So if you were disqualified from voting in the primary, you were effectively disqualified from voting, period. But there was nothing written anywhere that denied the vote on the basis of race in the general election. Third example, the adoption of the 19th Amendment, which we just celebrated the centennial of, was a major expansion of the vote to include women. There's a long history of what led to this action that took place over 80 or 90 years, beginning in the years before the Civil War, when a generalized women's rights movement was in some quarters focused in and zeroed in on the right to vote. That was the impact of the Seneca Falls Convention of 1848. The suffrage movement was eclipsed by the Civil War, as were just about all other movements for social change. It revived after the Civil War. There were internal splits and frictions within the movement, but finally, by the 19-teens, it became a strong movement, largely in response to Woodrow Wilson's call in World War I to make the world safe for democracy. And the advocates of women's suffrage began to argue, Mr. President, democracy begins at home, and you need to enfranchise, you need to approve enfranchising these women that represent half of the American population. I'm glossing over very quickly the controversy that ensued But in 1920, this amendment was adopted. But it was met with continued discouragement of women exercising that right, the tendency of many women to be directed by their husbands, and a low turnout among women during the early years in which they had the right to vote. This, incidentally, as I understand it, was the primary motivation for the founding of the League of Women Voters in the 1920s, to encourage women to vote through voter education and other means of civic engagement. I'm not doing this example justice, but it follows the same pattern of both expanding and restricting the use of the franchise. And my final example really covers the more recent civil rights movement. And here I've got a few examples, some of which I've already mentioned, of expanding the access to the ballot. A Supreme Court case in 1944 outlawed the white primary, and that was the end of that. The 24th Amendment, which we don't remember very much about, but which was adopted in the early 60s, outlawed the poll tax. And by the way, it was this amendment that was being referred to in Florida when the state legislature voted that in order to have their voting rights restored, ex-felons would have to pay all the court costs and fines and fees that they owed. The objection to that was this is a violation of the 24th Amendment. It's in effect a poll tax. And the courts decided, no, it is not a tax, that a tax has a specific meaning and this isn't it. And so those restrictions could stand. And then in 1965, perhaps most momentously, in response to the demonstrations and protests in Selma, the Congress adopted the Voting Rights Act. Now, the Voting Rights Act was legislation that was passed to implement the 15th Amendment from 95 years before. The second section of the 15th Amendment said Congress shall have the power to enforce this amendment by appropriate legislation. And that's what the Voting Rights Act did. The Voting Rights Act essentially shifted the presumption and the burden of proof. So if the statistics showed that there was a significant disparity in voting rates between whites and blacks, that disparity was taken as presumptive evidence of discrimination. And the state had the burden of proof to demonstrate otherwise. And in areas that had that presumptive demonstration of discriminatory action, if the state was going to do anything to change the rules or requirements or procedures for voting, it had to first be approved by the Federal Department of Justice. And that resulted in a huge expansion of voting participation, particularly in southern states, that suddenly made it necessary for aspirants to political office to appeal for support from African Americans. George Wallace, who earlier in his career had vowed segregation today, tomorrow, and forever, by the last time he was running for governor, was appealing directly for black votes and apologizing for his earlier stance. And the number of black officials in the South multiplied exponentially. But in the years after those first things happened, some states began to stiffen their voting requirements with residency requirements, proof of residency, photo IDs, and so on, that had the effect, again, although they were face neutral, they had the effect of restricting participation by African Americans. And as many of you know, just a few years ago, the Supreme Court, in the case of Shelby County versus Holder, I use the word curtails the Voting Rights Act. They didn't declare the Voting Rights Act unconstitutional or illegal, but they invalidated the pre-clearance requirement by the Department of Justice. And the reason they invalidated it was not that they were opposed to pre-clearance per se, but rather that the list of jurisdictions specified in the act that required pre-clearance had not been changed since the act was adopted in 1965. And Chief Justice Roberts, who wrote that majority opinion, said our country has changed. And his evidence was that there were counties on this list requiring pre-clearance that now had higher voting percentages than some who were not on the list. To which Justice Ginsburg replied in her dissenting opinion that this is like throwing away your umbrella in the rainstorm because while you had your umbrella, you didn't get wet. And her argument is, yeah, these conditions occurred with the pre-clearance requirements in place. The Supreme Court essentially said Congress can update this law if it wants, either by reaffirming these counties with reasons for doing so, or developing a current list of where pre-clearance would be required. Of course, Congress, then as now, was split between one party controlling the House and the other party controlling the Senate, and there was absolutely no reason to believe that Congress would take those actions. So that's part 3 of the talk. And I know I'm already over 45 minutes. I'll probably be closer to an hour, but I don't have much more left. But part 4 talks about our current condition, in which it seems to me the act of voting has been weaponized. With few exceptions, such as after the Civil War, up until now, the act of casting a vote, not who you vote for, but the act of casting a vote, has been understood as a nonpartisan act. Both parties encouraged registration. Both parties encouraged voting. As an example, the Postal Service, in the middle of the 1964 campaign, issued a stamp promoting register and vote. And it's in that same nonpartisan spirit that I planned and put together and am offering this talk tonight. But in recent years, an overlay of partisanship has been established over the right to vote. And this has been the combination of 2 forces: the realignment and polarization of the political parties. Until the last 40 years or so, the parties overlapped ideologically. There were liberal Republicans, there were conservative Democrats. In the years since the mid-60s, first gradually and then at a more rapid pace, the parties have polarized ideologically so that one party stands to gain and the other party stands to lose from more or less voting. And the reason that that's so is the second overlay factor, the demographic trends of the country. The way the population is growing, it's expanding among groups that are more likely to vote for one party than for the other party. So that one party has an interest in expanding the vote, the other party has an interest in restricting the vote. Now, it didn't have to be this way. There was serious discussion within the Republican Party during the George W. Bush administration of broadening the base of the Republican Party by appealing directly to Hispanic voters, which at that point were a largely undecided constituency, and that this would best be accomplished by a program of immigration reform that President Bush championed. But the fact was the Republican Party went in a very different direction. And so the Democrats have had an interest in enlarging the vote. Republicans have had an interest in restricting the vote. Now, neither party has argued that bluntly. The Democrats have argued that voting should be made less of a burden by early voting, voting by mail, same-day registration, and so on, and have not directly answered the question, is citizenship less meaningful if it has somehow been made more easy? The argument for restricting the vote has been to protect voting against abuse, the desire to protect against vote fraud, multiple ballots being cast, and so on. The argument has been made that there's virtually no evidence of vote fraud. And there's an answer for that that the Republicans have so far not made very much, which is sort of the reverse of the Ginsburg versus Roberts argument. Yeah, there's very little evidence of it. We have these restrictions in place. You go to universal mail balloting or to this or that, and then you'll see massive voter fraud, although this is somewhat counteracted by the experience of states that have tried it without those results. Now, in my judgment, I think we're missing something. I think we need, but are not likely to get, a constitutional amendment doing what the original Constitution did not do, and that is to establish an affirmative constitutional right to vote, from which disparities among the various states in their eligibility requirements could be eliminated or outlawed. And while I'm at it, I'd also have this constitutional amendment effectively overturn the Buckley versus Vallejo case of the 1970s, which is the one that decided that money equals speech rather than money facilitates speech. And that in turn would provide the basis for overturning Citizens United. But that's not going to happen. So what can we do? First, sign the Beth Emet commitment card, as Jan urged us to do. Then vote. Whether you vote by mail, early, or in person on election day, pick one of the three. And then encourage others to vote. And I'm going to stop at that point, except for one thing. I want to end with a short public service announcement. The adult education schedule that was distributed at the high holidays inadvertently omitted 2 classes that I have a part in. And while they're now correct on the website, not everybody has looked at it. So I want to make sure you know that Current Politics will meet on Wednesday, October 28, right before the election, a week before, and again on Tuesday, January 12. And Not So Current Politics will meet on Wednesday, December 9, both of which will meet from 7:30 to 9 o'clock. Well, I'm between 45 minutes and an hour, but I want to reserve the rest of our time for discussion and questions. And for that purpose, I'm going to take back the screen, or try to. I'll invite Marcy to recognize people who want to get into the discussion, if that's okay with you, Marcy.
Happy to help. And
how would you like people to indicate that they want to participate?
Yeah, sure. You can either use your little hand in those reaction hands. Let us know that you want to say something, or just give a wave. Remember, there's a couple of screens here, so if I don't, we'll try to keep searching and looking.
And when you're recognized, unmute yourself for your comment or question.
Yeah, for sure. And if you're willing to, it's nice for us to see you when you're speaking. Charlotte Jaffe, go ahead. Unmute yourself, please. Charlotte, we can't hear you. You have to unmute yourself. I no longer can unmute you. So, are you able to do that there? Let me try it again, but I don't think I can just ask you to unmute.
The way you unmute yourself, if somebody doesn't know, is you take your cursor down to the bottom left of your screen, and if you see a microphone with mute under it with a cross out through it, click on that so you'll eliminate the cross out, and then you'll be able to speak.
I'll work with Charlotte and Jerry. I know Jerry Fink had a question. Maybe we'll start there first too. See if I can help her.
Okay, I've unmuted. Can you hear me?
Yes.
Okay. I chatted you, David, but you were in the middle of your presentation, so that was unfair. My question is, in light of our federalism, any of these amendments have to recognize the distinction between state voting and federal voting. And in fact, one of the amendments you cited was very explicit that the poll tax applied only to elections for certain federal offices. The amendment reducing the age of voting to 18 did not have any such restrictions. And it seems to me that there might be a problem with regard to votes involving non-federal issues, non-federal offices. And a lot of the action these days is within the state legislatures, whether it's abortion laws or any of the laws, including laws with respect to very important public policies. So to what extent is the amendment process going to be restricted if it cannot extend to voting for state legislatures or state constitutional amendments?
Well, the premise of your question is right, that these federal amendments do not automatically and by themselves apply to state elections. I believe that in the case of the 26th Amendment, the one regarding the 18-year-old vote, I think all or almost all of the states subsequently changed their own regulations to conform to that age requirement for the specific reason that it would be too cumbersome and confusing to have different requirements for federal and state eligibility. In the case of the Senate provision, that was necessary in the 24th Amendment, but not in the earlier amendments, because in the earlier ones, senators were elected by the state legislature and not by direct election of the people. In the case of representatives, the Constitution itself had suggested that those eligible to vote for representatives would be those eligible to vote for the largest house in the state legislature. So those earlier amendments were accounted for in other ways. But your premise is correct, but I think the states have acted long ago to avoid that problem.
The specific reason I reference this is I recalled years ago when there was a program called Ethics and Policy, or I'm sure you're aware of the proper name of the show, but Justice Scalia was on that show, and he made it very clear that from a strict constitutional point of view, not his personal view, he made it very clear, but from a strict constitutional point of view, he said there was nothing that would prevent a state from enacting a religious requirement, religious test requirement, to voting in state non-federal issue or offices. And I found that shocking, but he said from a strict interpretation of the Constitution, a state could do that. So I thought it important that we consider this distinction between state and federal rights.
Yeah, I'm not a constitutional lawyer, but as I remember, Article 2 of the Constitution provides that there should be no religious test for any public office. And the question is that just for federal public office, or does it apply more universally? And Justice Scalia is applying his originalist theory of interpretation. I don't know whether that has by implication or otherwise been extended to the states, but I do not want to suggest that he's mistaken, but his interpretation is coming from a particular perspective.
Thank you.
Charlotte, did you want to, you just muted yourself again. Undo it. You weren't muted before, but then you got muted again. There you go. Now we can hear you.
You're on.
So ask me to repeat if I don't. Anyway, I'll do it fast. School, in civics class, our class learned that the Constitution was written purposely, some words in the Constitution were purposely ambiguous. And I think the word right was one of the words in that, in that lecture that she shared. I'm wondering, if that, are you hearing me, anybody?
Yes, we can hear you.
Oh, okay. So, when you were talking about the word you know, right, the right. I'm confused because I know what you're saying, but I just don't understand how, when is a right not a right?
Well, she's saying
Your
the same
definition.
thing I am, although she said it better. It's not that a right is not a right, but that it's ambiguous how absolute a right is and whether it can be overridden by other considerations and under what kinds of circumstances. And I was suggesting that the answer to that question depends upon where you think the right came from. That some rights had strong, as it was used at the time of the Constitution, that some rights had stronger standing than other rights because of what their origin was presumed to be.
Wow, so that had to take a lot of investigating, a lot of analyzing, I guess, of the word.
Well, but it was a deliberate ambiguity. This gives me a segue to suggest, although it's a little tangential to tonight's talk, that if you ask after the original intent of the Constitution, you will find that the original intent of the Constitution was to be ambiguous on several points, either to permit case-by-case argument or to kick the can further down the road because they didn't know how to resolve it. And so the notion that Judge Barrett and Justice Gorsuch and others have said is, you know, we interpret the Constitution according to what it meant to the founders. I think that's going to get to a dead end because what it meant to the founders in large part was they weren't going to say.
Right. Yeah. Thank you.
Sure.
I'm scanning again, so try to give me a Malcolm.
Yeah, this is a little tangential, but I thought I'd bring it up. I'd heard that the original draft of the Declaration of Independence by Jefferson guaranteed rights to life, liberty, and property. But that Franklin told him that if he said that, the northern states would interpret that as slavery and they wouldn't accept the Declaration of Independence. I wonder if you've ever heard that.
Yes, I've heard that. I can't verify whether it's true or not, but I have heard the same thing. And of course, life, liberty, and property was praised from the French Revolution.
Okay. I always have this vision of Franklin sitting in a room with a candle thinking, I can't use property. What am I going to use instead of it? And coming up with Pursuit of Happiness.
That could well be.
Okay, that's all I have to say.
Okay, thank you for that question and comment. And anybody else trying to get in there, you can unmute yourself and let us know, especially if you don't have your camera on. Or you can even type it in the chat. David might even take a comment and not just a question.
Certainly. I welcome them.
Anybody want to unmute themselves?
Barbara is raising her hand.
Barbara?
Yes.
Thank you.
So if the legislatures were to select the electors, how was that done differently in different states, or how would that happen if it came to that, or if Trump tried to get people to do that?
Well, I mean, the way the Constitution is written, each state can decide how its electors are chosen. It's just happened that over time, they've all decided in favor of popular vote election. What is untested is whether after deciding on popular vote election and setting the election in motion, they can disregard the results and reclaim the power to select themselves. That's never been tested. But as I mentioned briefly, that was one of the proposals that was floated in Florida after the 2000 election, when it became clear that the election would come down to the results in Florida.
Would it just be a majority vote of the legislatures?
If that's what they provided for.
Yeah.
Now, my proposed constitutional amendment that will never happen would take care of this and several of the other problems that have been mentioned.
David, the very reason we have these problems is because the nature of the political alignments, as you discussed, make a constitutional amendment impossible to get the number of states to vote in support of such a constitutional amendment. And even then, I suspect, as you said, the nature of legislation and compromise is such that any such amendment would probably have wiggle room for interpretation and later discussion. I'm really concerned, quite frankly, and this is something you raised at the last session you had. Given all of the possible permutations of interferences within the different states, and even this untested idea that a state can revoke or retroactively affect its electoral vote, I honestly see a very uncertain result with all kinds of means of litigation and uncertainty, many of which will be based on potentially valid legal arguments. And I think that your current politics and not so current politics are going to blend, because in December, we're going to have still current politics.
Well, Jerry, I welcome that comment. The first part of what you said about a constitutional amendment, I think you're absolutely right. And that would apply not only to my suggested constitutional amendment, but to any constitutional amendment on any subject right now. I don't think there would be a way to get it approved. I think you're also right in your concern about the election. And it may be that by December the 9th, we still don't know the results of the election. That happened in 2000, if you recall. Interestingly, in 2000, it was all of the pundits and commentators who said this is very urgent, we've got to get this resolved right away. And the American public was surprisingly patient with waiting out the resolution of the election. I don't know whether that would happen this time or not. I'd be surprised if this time it came down to one single state in the same way that it did in Florida. I think you're right. There's all kinds of potential for disruption and confusion. I think both parties are aware of that. I think there's a whole couple groups of lawyers that have been marshaled to try to anticipate what could happen and what they would do if it did. The obvious way to avoid that, and I don't mean this as a partisan comment, but the obvious way to avoid that is for one or the other candidate to win in a landslide, so that the margin is sufficiently great that even if you made allowance for a reasonable number of such challenges, they wouldn't alter the final result, and that would be a big deterrent to the challenges ever being placed.
I would agree that that's the only perceivable way that this would be avoided. And you can tell all those lawyers that have been working on this, they're the ones that are walking around like zombies from not having any sleep.
There's a question from Fran, I think.
Hi, it goes along with what we were talking about with President Trump repeating on numerous occasions that we'll wait and see, that he is not committed to a peaceful transfer of power if he loses. What do you see? I'm curious about your thoughts. What are the options? What would happen if he absolutely refused to accept the results of election?
Well, let me say first that I may be in the minority in this, but I don't take very seriously these individual comments that he makes. To answer your question directly, what would happen if he refused to accept the results of the election? On Inauguration Day, he would be escorted out of the White House by the military or the police.
Mm.
Yeah. Malcolm, do you have another question or comment?
Yes, I do. I had heard that most states have a law saying that the electors had to vote for the candidate who got the majority of the votes in that state. That's one question. The second question is, there's one state in the United States, Nebraska, which splits its electors, and I don't know how it does it, how it decides how many electors go to each candidate. And I was wondering if you were aware of that.
Well, let me take that part of the question first, because that's easy to answer. There are two such states, Nebraska and Maine, that split their electoral votes. And the way they do it is each congressional district casts one electoral vote for the winner in that congressional district, and the overall winner of the state popular vote gets the remaining two electoral votes. This has happened on some occasions. For example, in 2008, President Obama received one of Nebraska's electoral votes because he carried the district in suburban Omaha, where Biden is currently well ahead as well. I don't think there's actually been a case of Maine splitting its votes, at least not one that I'm aware of, but they determine their votes in the same way, congressional district by congressional district. Now, you suggested at the beginning that you've heard that most states have a law requiring their electors to vote with the majority of the state popular vote. I meant to look this up and forgot to do so, just how many states it is. I think it's in the 20s, but it may be higher. Some of those have enforcement provisions, some of them don't have enforcement provisions. There has never yet been a case where these errant votes by the faithless electors would have changed the result, but that doesn't mean that there couldn't be. And as I mentioned during the talk, the Supreme Court this summer upheld the ability of the states to require that their electors vote as the state popular vote went. You realize, of course, that that was not the original understanding of the Electoral College at all. The original understanding was the electors would get together in each state and they would decide who the strongest candidate was, and there wasn't a direct popular vote. That all came about gradually.
It's all very frightening, David. Cheer us up.
Pardon me, Helene?
I said, cheer us up. It's really scary to think about what's going to happen.
Well, it's really scary to think about all of these hypotheticals. It may well be that none of them happen. But what'll cheer you up is go vote.
Mm-hmm.
I've already sent in my vote ballot.
Don't vote again.
Yeah. All right, anybody else want to pipe in here? Charlotte, I think you're muted again.
Yeah.
There you go.
Okay. Tell us a little bit about the 25th Amendment and how we might be able to implement that amendment in this case that we're facing with this candidate.
Well, the 25th Amendment has nothing to do with voting. It has to do with succession to the presidency if the presidency or the vice presidency became vacant. And it's complicated and it has several parts. The first thing that it says, which it may strike you as odd, but it never been clearly established before, is if the president dies or resigns and the office becomes vacant, the vice president will become president. Now that's what had happened all along, but it had happened as a matter of practice. There was nothing that said that. The Constitution said the duties of the office shall devolve to the vice president. And it was John Tyler who said, if the duties of the office devolve to me, then I'm the president. And he referred to himself as the president, and subsequent cases did the same. The second provision of it is that if the vice presidency becomes vacant, the president shall nominate a candidate for vice president, and both the House and the Senate are called upon to approve or not approve that choice. And that's what happened in the two cases of Gerald Ford and Nelson Rockefeller. Both of them became vice president in that fashion. The third part has to do with presidential disability that the president recognizes. So and this has been invoked only by George W. Bush on two occasions when he was going into the hospital for a colonoscopy and knew that he was going to be unconscious for a period of a few hours. He invoked that provision to transfer power to Vice President Cheney. And then when he came back into consciousness, he invoked the provision of that section to reclaim power. The fourth section has to do with alleged presidential disability that the president himself does not acknowledge or rejects. And it says that a combination of the vice president plus either a majority of the two houses of Congress, or, I'm sorry, the vice president plus either a majority of the cabinet or the majority of a group identified by Congress for this purpose can declare the president to be incapacitated. And if that happens, the vice president assumes the duties of the president. The president can determine then when to resume those duties. And if the vice president acting as president disagrees, then it goes to a majority vote in Congress, and a majority of both houses has to vote to keep the president considered disabled. And there is a fifth section, and I honestly don't remember what it is. I'm sorry. But none of the provisions of that amendment relate to an election or to voting.
When was Nelson Rockefeller vice president? I don't remember that.
He was vice president after Gerald Ford became president. That vacated the vice presidency, and under the terms of the 25th Amendment, Ford nominated Rockefeller to be his vice president, and the two houses of Congress confirmed that, and Rockefeller, I believe, was confirmed in about November of 1974. So he served for about 2 years. Ford decided when he became a candidate for re-election that he would not retain Rockefeller as his vice president if he won the election, and named Bob Dole as his running mate.
Thank you.
This is Stump the Professor.
Okay. My other question is, who are the electors in Illinois? I don't recall seeing them on the ballot, but I mean, are they?
They're not on the ballot. They're not on the ballot because Illinois, like most states, as a convenient shorthand to make the ballot simpler, has written the ballot as though you were voting directly for the presidential candidates.
Right.
But in fact, you are voting for the slate of electors who are pledged to that candidate. So if you check, for example, that you're voting for Trump and Pence, you're actually voting for 20 people who will be the 20 people who will cast Illinois' 20 electoral votes. And likewise, if you're voting for Biden and Harris or any of the other candidates.
But who are these people and how are they selected?
I don't know who they are, frankly, but they're selected typically by the state party organizations. So in order to reward loyal Democrats, for example, the state Democratic Party will offer them the opportunity to be one of the electors.
Thank you. And actually, I have one more question, and that is, I was living in Florida in 2000, and I don't recall anybody in Florida suggesting that we should let the legislature decide how our votes should have gone. I remember that we wanted them counted and that our state Supreme Court said they should be counted.
Yeah, it was not a popular view, but there was at least one or two members of the Florida legislature, and I can't recall their names, who had suggested that as an alternative. It was not seriously entertained by anybody.
Okay, thank you.
Jan is trying to talk.
Thank you. I love it, Susan. You've got your eyes. Jan, go for it.
Unmute, Jan.
We can't hear you.
Okay, so what if people voted for delegates who were going for Bernie Sanders? What would happen to those delegates now? Would they, is that have any, oh, that's a different thing
No,
altogether.
you're confusing
I'm
delegates
thinking,
and
I know,
electors.
as soon as I said it, I realized it. But since I have the floor, a couple of people mentioned, or somebody mentioned that there was nothing on that commitment card if you had already voted. We just want your name, just so we can count you. Thank you.
Would somebody explain? I don't even know what that commitment card is.
It's
Did
because
we
we
get-
want 100% voting on in the congregation, and we're trying to get people to commit to saying that they are voting or have voted just by putting their name in. There are other things that you can put in if you want, but basically we just want to count the number of people who are going to be voting.
Oh, I voted. So where do I?
So just
how do I?
the commitment thing is on the chat. From Marcy Dickman to everyone election card.
I'm going to put it in again as a commitment card because that's the proper title.
That's a good idea.
Importantly,
Sorry.
it does not ask how you voted.
No, no.
Thank you for asking that question. We had trouble getting in. Thank you, Marcy, for sending out the information. And so I didn't know what that was all about either. So I'm glad you repeated.
Mm-hmm.
And again, we apologize for the glitches tonight.
I'm going to take a picture of that. Keep it there. Oh no, I have it.
Just put your name in and.
Oh, you mean right there? I can do it.
Yes.
Click on it.
Hit the blue.
Click on it. If you click on it, it will take you to the card. I just want to scan one more time and see if there's a final comment, or David, if you want to add anything. And I know there's a lot of gratitude in this group.
Well, I think I put in, if anything, I put in too much already.
Okay. Well, thank you.
Covered a lot of ground.
The next date is October 28th. There's many things between now and October 28th, but we will hopefully see all of you here for another class with David Zarefsky on October.
Thank you.
Thank you.
Thank you. It was so well organized.
My pleasure. Thanks to all of you.
Unmute everybody.
Can I just ask a question? It says, do you plan to vote? What if I voted already?
Doesn't make any difference. Just put your name in, please.
Okay.
And send it. Thank you.
Or just put yes.
Okay.
Thanks, David.
Thank you, David.
My pleasure.
Thank you.
Thank you.
Thank you.
Thank you very much.
Get up to the top.
Jan?
Good night, everybody. Have a nice Shabbat when it comes.
Can you explain that?
Pardon me? Ask that again.
On the form, the very last question says, if you have any questions, please submit them to Beth Emet. And then it says your response or your answer. And if you say like, thank you, or put any English, it says
no. Basically, Paul, it's for people who really aren't sure how to vote, how to get to the voting place, or where to vote, or how to get their ballot.
But it requires a physical number, so that's confusing. I mean, what do I?
Yeah, I think the whole thing is confusing. I think we needed to just make it very simple. And unfortunately, it isn't.
That's Google Forms that's responsible for that.
It's Google Forms. That's right.
I can't get my email in.
Don't worry about it. We know your email.
Okay. Oh, wait, well, I didn't submit.
You don't even have to. Just put your name in and send it.
Oh, okay. Now
I copied that link that Marcy posted and pasted it into a potential email to send. So when I opened that link in my email, or even if I put it in Word or something, would it expand and show me what it's all about?
It should.
No,
Yeah, okay.
you'll have to ask Judy about that. She made up this. Google Forms is kind of confusing sometimes.
Mm.
Well, somehow I lost the meeting.
I did want to say thank you for trying to get everyone's civic commitment, and I really appreciate the effort and hope you get 101%.
Me too. Thank you, Paul.
Is
And
that
just
like
hit
voting
submit
twice?
at the end.
Just
Darcy, did other people have
Yeah.
trouble? Did other people have trouble getting in, or I don't know? It just kept going
Yes.
around.
Yes.
There were some errors made in one of the emails that went out today. So
Ah.
I apologize for it. And
Well, I'm glad I wrote you and then Danny and you
I
sent
am
them
also
back.
very glad.
Yeah. Okay. Thank you, David. We got most of at least
Sorry about
half of.
You got
You
some
need-
of it, and we also were able to record most of it. So
record so we
get
could go
that.
back. Yeah.
Yeah.
David, we saw you on Channel 5 a while ago.
Last week.
Yeah.
Last
You.
week, yes.
Does that make you famous or